morning, good afternoon, good evening. It's Atlanta Discuss. Yes, it's Friday. We always come to you with something that reverberates with the political, landscape of the world, of Africa, sometimes of Nigeria. Nigeria, like I've always told you, is the largest concentration of Black people on the planet. I've said it before, one out of every four sub-Saharan African is a Nigerian. One out of, every six Black person on the planet is a Nigerian. But there was a court case recently in Nigeria, a lot of political issues going on there, especially when has to do with River State. There was a Supreme Court judgment, which everybody has been talking about, Governor Fubara versus former Governor Wike and all that. But those are not the main issues. The Supreme Court has ruled, and I mean, I'm not a lawyer, but we need to hear from the legal mind. That's why we call on the legal luminary, the legal salamander himself, Jibrin Samuel Okutepa, SAN. Welcome, sir, to Atlanta Discuss.
Thank you, Ade, my brother. How are you?
I'm doing fine. How are you, sir? How are you doing?
I'm fine. I'm sure you are enjoying the actions and actions of Donald Trump, your newly sworn president.
Yeah, it's interesting. Some of them remind you of Nigeria.
Thank you, my brother.
Yeah, we can relate. So it's our tradition. We go for the juggler. I know you're a very busy man, so always appreciate when you give us time like this. So the Supreme Court has spoken, and I read some things from so many sources. I think it was Professor Odinkalu that said that the Supreme Court judgment itself was not fair, that they didn't really deal with the crux of the matter. And I think he also mentioned, I'm paraphrasing now, that there was a precedent judgment of a 7-man panel of the Supreme Court in the past about decampment and all that. But the way I want us to look at it, we're taking one issue at a time. I know the judgment has been given, but do you think judgment was done on the issue of decampment, for example? Let's start with decampment. Or if you want to take all the whole issue, I'll give you all the time you need because we need your knowledge in this area. So I'll leave it over to you now, sir. Yeah.
Well, thank you, Ade. I was anxious and I was anxious to read the judgment of the Supreme Court. And I'll take in my time to read that judgment, especially the majority, the lead judgment delivered by my Lord Honorable Justice Emmanuel Akomoye Agim, JSC. And what I deduced from that judgment is that first, that the governor of River State appears to have allowed himself to be carried away by integrity and honesty of purpose when there were pending litigations at the time. A meeting was said to have been held between him, his estranged godfathers, and the President of the Federal Republic of Nigeria. An instruction was passed that parties should go home, resolve themselves, and have the dispute resolved. And I think the governor, pursuant to that respect, which I believe he had for the highest office of the land, decided to withdraw some of his counter affidavit to some of the matters that were pending. And from what I have read of judgments of the Supreme Court, that singular honest decisions by the governor to withdraw his counter affidavit, in which all his ammunitions and arsenal to decide and deal frontally with his political enemies should have been there and used, having been withdrawn and struck out. It appears, therefore, before the trial court, that there was nothing on the other side of the scale to believe that anything had happened. And so the judgment was delivered against the governor by the Federal High Court. That judgment was affirmed by the Court of Appeal, and that judgment that was delivered by the Federal High Court and affirmed by the Court of Appeal were later part of the exhibit in a matter before the court, and which ultimately came to the Supreme Court. And when the matter came to the Supreme Court has to decide the matter on the basis of the unchallenged evidence, and therefore came to the conclusion that it came and made the orders in the judgment that it made. And so there are statements, in my view, therefore, from the look of things, the real issues of whether these 7 members of Rivers State House of Assembly had defected or not defected were not frontally tackled by a counter affidavit and Hansard and documents and video that should have enabled the Supreme Court to decide. But be that as it may, when one reads the judgment of the Supreme Court from the point of view of the unchallenged evidence, the Supreme Court came to the conclusion and made far-reaching decisions in favor of these persons that all Nigerians know committed what looks like constitutional sacrilege, and then they now got a favorable judgment from the Supreme Court. But having said that, I have also looked at the relief that was granted by the Supreme Court in the lead judgments of my Lord, Honorable Justice Agim. And there are 3 very fundamental reliefs, which in my view, with profound respect, I do not think that it's a proper relief to be granted in a very serious matter of this nature. Permit me to look at those reliefs. Those reliefs are 3, and they are contained in the concluding part of the judgments of my Lord, Honorable Justice Agim. And this is what my Lord Agim said: for avoidance of doubt, it is hereby ordered that 1, the Central Bank of Nigeria and the Accountant General of the Federation should forthwith stop releasing and paying to the government of Rivers State, its organs, departments, and officials any money belonging to Rivers State until an appropriation law is made by Rivers State House of Assembly, constituted as prescribed by the 1999 Constitution. 2, the Right Honorable Martin Chike Amaule and 26 others should forthwith resume unhindered legislative sitting as Speaker and members, respectively, of Rivers State House of Assembly. The House of Assembly, the Rivers State House of Assembly should resume sitting with all elect members forthwith. Those were the 3 reliefs granted. I have a problem with those reliefs. Okay. Number one problem I have with the relief is that the right of any state to the revenue in the consolidated revenue account of the Federation is a constitutional right. And that right, in my view, no court of law has the jurisdiction with profound respect to the Supreme Court to make an order denying the Rivers State House of Assembly the right to the revenue in the Consolidated Revenue Fund under Section 160, 161, 162, 163 of the 1999 Constitution. The right to receive revenue must not be confused with the right to spend the money that was received from the Federation account. So in my humble view, profound respect and meaning no disrespect to the Supreme Court, the order made denying Rivers State the right to its money in the Consolidated Revenue Fund was a right, an order that was made too far. And I think there is a need for the Supreme Court to be very circumspect and careful when making such an order, even in the face of the unchallenged evidence from one side of the party before the court. Why did I say so? The constitutional right of entitlement of a Nigerian citizen cannot be denied that citizen of a government. Two, I would have not had a problem with the order of the Supreme Court if the order was that money meant for River State in the Consolidated Revenue Fund, upon being received by the River State government, be not spent, be not used, unless there is a valid appropriation law duly passed by River State House of Assembly in accordance with Section 121 and 121 of the 1999 Constitution. That was not the order that was made. But the order that was made, in my view, is an order that had been made, if care is not taken, not only against the River State government, but it's against the entire work of River State. Because in my view, there is a provision in our law that entitles a governor of a state to spend the revenue of this money meant for the state within a period of 6 months before you can have an appropriate appropriation law. Are we then being told now that the River State government should be castrated and not to have its money even within the window period of 6 months? Is this order not intended, not going to grant the River State government? So I have problem with the first order. Second problem I have, with profound respect, is that even in these judgments, the Supreme Court itself took judice of the point that the 27 members of River State House of Assembly were seen on radio and television waving flags of decampment and swore to an affidavit that they have decamped. And that is explicit in the judgment, in the contributing judgments of my Lord, Honorable Justice Chioma Iheme, JSC. In that judgment, His Lordship was made a profound statement that suggests to me that the Supreme Court was aware that these people have, on several occasions, just a moment, so that I can look at the exact page of that judgment by His Lordship, Honorable Justice Chioma Iheme. And I was worried that that aspect of the statement was made by His Lordship. Just a moment, because it's a bulky judgment. And I needed, very sorry, it's a bulky judgment. Well, while I look at it, my worries stem from the fact of what His Lordship said there, that why the decampment is much more than waving of flags and swear to an affidavit. Yes, I'm almost there. Thank you. Now, why I say that from the look of things and from the contributing judgments of my Lord Honorable Justice Chioma Iheme, JSC, at page 7 of His Lordship's contribution, this is what my Lord said. Defection is a destination that must be arrived at, and the defectors acknowledge by the political party that the individual or group wish to defect to. Whereas in this case, the same political party fails to acknowledge the defectors. In the eyes of the law, the individual or group cannot be said to have defected. Defection, therefore, must go beyond waving of the flags on the television and swearing to an affidavit. It must come to a conclusion and not to be allowed to hang or sit in the limbo, unquote. I'm afraid the logic of this reasoning, in my respective view, has created another fertile ground for political rascality in Nigeria. Why did I say so? We all know what the politicians do. We have seen them. Does this accord with the correct interpretation of Section 109, subsection 1G of the Nigerian Constitution? In my respective view, and without meaning any insult to the Supreme Court, this interpretation is extraneous. It's not in tune with Section 109, subsection 1G of the Constitution, because everyone in Nigeria, including the deaf and the dumb, we're all aware, and it's all over in the internet, where these 27 persons have gone and said that they have decamped. The notorious fact that the party upon which they were elected, which is PDP, had no division. And therefore, in my view, the Supreme Court ought not to have made this such a blanket statement that has the potential to make Nigerian politicians desecrate our constitution with such audacity of impunity, as if the constitution does not matter. Mark you, it is the decisions of our courts approving iniquitous conduct of political class in the road to political offices that have been them to disrespect the sovereignty of the people. Therefore, I think that the Supreme Court of Nigeria ought to hold the politicians accountable to their words. After all, we were told that admission on oath is binding. And so if somebody, a full adult, who is a lawmaker, decided to go to the court, sworn to an affidavit that I have decamped, what evidence of registration and party membership do I need? Particularly in the circumstances where there appears to be some of political conspiracy to take benefits of the decampment and defections by unseen hands in the Nigerian political terrain for purposes of political advantage, advantages that are not rooted for the best interest of the masses. And I think there is a need for us to take a look at Section 109, subsection 1G, and permit me to pick my constitution.
Please go ahead, sir. That's what I want to hear.
The Constitution is Section 109, subsection 1G, that was interpreted, is very clear in language, in purport, and in understanding. And the principles of law is that we must give natural interpretation to the provisions of the Constitution. We don't import into the Constitution what is not in the Constitution. Section 109, subsection 1 says, quote, a member of House of Assembly shall vacate his seat in the House if, subsection 1G, he being a person whose election to the House of Assembly was sponsored by a political party he becomes a member of another political party before the expiration of the period for which that house was elected, provided that his of the latter political party is not as a result of a division in the political party of which he was previously a member, or of a merger of two or more political parties, or factions by one of which he was previously sponsored, unquote. There is nowhere that the requirement of law was that you should show your membership card as a function of defection. They say if he defects, there is on social media, there are videos of all of these, including affidavits that say we have defected. That is confession and admission. Whatever a party has admitted needs no further proof. This is the principles of law of considerable antiquity that I know. But who am I? What do I know? Their lordship has spoken. That represents the law. But I have said, and I want to say, that judgment or court should solve problem, not to compounding it. A judgment that compounds problem and not solving it is a judgment that is likely to lay foundation for political unrest and political anarchy. And my view is that we must be careful how we play our cards, because we need peace and stability in the nation called Nigeria for every profession to operate, including the profession of law. And so for me, we owe a duty to the country, our motherland, our fatherland, the Constitution, in our adjudicatory and interpretative and professional practice, not to aid and abet the heating of politics that leads to a catastrophic end. That's my view for now on this matter.
So, you've spoken very well, and I like the way you spoke, interpreting the law, what the law says and all that. But for the governor, for example, does he have any other recourse to justice at the moment?
Well, until the judgment of the Supreme Court is set aside, the only recourse to justice is for him to consult his political wisdom and dexterity to swallow the pill, to work with people who hate to work with him.
Yeah, he sent a letter, I'm sure you've seen it, to those 27 members for a meeting. And I think part of the content was that they should agree on where they will sit, legislation and all that. But I think those ones have refused to attend that, to hear the call. More so, the APC chairman in Rivers State has said that the governor should resign in 48 hours or be impeached. And don't you think that leads more to anarchy? Because the governor being an Opobo man, the job people have been, beating the war drums and all that. Rivers State, as you know, is all producing and slightly unstable. So it just shows that everything leads to anarchy, and that's not good for our democracy the way it is. So if those guys don't want to go to Mohammed is not going to the mountain. Wherein lies the constitution and the rule of law in all this, Lanet Silk?
I will answer your question by an analogy that is not related to the personalities involved. If peradventure Mr. A is being surrounded by a group of people well armed with AK-47, arms and ammunition, and they have called, and that arms and ammunition was duly licensed for purposes of slaughtering Mr. A. What do you think is Mr. A's surviving strategy?
Fight back, shoot back.
So for me, in the beginning, like I said, I think the governor of Rivers State seems to not to have properly learned the, the, the principles of Nigerian politics. The principles of Nigerian politics doesn't seem to rest on what looks like decency. It is who has the power, who has the authority to do what is right, what is wrong, that always triumphs. When you witness Nigerian election, you may not need to ask me the question you have asked, because unlike what obtains in other clime, you see that on the day of election, those who have responsibility to protect voters, allow voters to exercise their rights, are part of the people that always gang up and intimidate voters or do what is not democratically correct, so that the people who have been destined by the power that be to win will win. So for me, the governor will need to use all the wisdom available at him, at his disposal, political connections he needs to have, those who can talk to the people who have the knife to his jugular now, and begin to do what he needs to do, including play the game that they both know how to play to survive. Because the music, with profound respect, has changed to war song. And I think the governor must dance the music to protect himself. That's my reaction to your question, sir.
All right, fantastic. Let me quickly read to you something Professor Chidi Odinkalu, I'm sure he's your good friend, said in his column yesterday. He said, and I'm reading, directly, there are 4 glaring problems with the Supreme Court judgment. The first is not what is in it, but what is missing. Lawyers claim that equity does not act in vain. The Supreme Court did not bother to provide any reasoning or justification for its orders.
Even before you read it, I have said so from the beginning.
Yeah, I know. I'm trying to. Yeah,
for instance, they relieve sought in this whole thing by these 27 members, Rivers State House of Assembly, using the name of Rivers State government, are declaratory reliefs. And there are authorities, including authorities from the Supreme Court, that a wrongful conduct is not a license to get favor from court of equity. And so how did these 27 members of House of Assembly who went on televisions, who went to courts and deposed to affidavit that they have defected, will turn around to get equitable remedy from our courts? It's a matter that beats my own imagination. So there is a need for us to be consistently consistent in the principles of law, because if in the court of equity, wrongful passport, misconduct, which is glaring to everyone to see, have become a license to favor in our court, then why should anyone think of being decent? So for me, it was not sufficient for their lordships to just say that defection is much more than waving flag. Defection is much more than swearing to an affidavit. Why should a man who swears to an affidavit of a fact he did not mean be granted favor in the court of equity? Because in the court of equity, before you can be entitled to relief, you yourself must be clean, because equity does not aid those whose hands are not clean. How neat and clean are the hands of these people that got this equitable relief in the desecration of the Nigerian Constitution? How neat and clean are their hands in upholding the Nigerian Constitution? How neat and clean were their hands in being truthful to the issues they say that they have done and turned 360 degrees to say they have not done so. In other words, there are two conflicting affidavits from lawmakers. The one that says we have defected, another one later in time that says we have not defected. What makes you to believe the latter affidavit compared to the earlier affidavits? How do you come to this conclusion to grant them the favorable indulgence? These are my worries with the conclusion of the court. Yes, the affidavits were unchallenged, but you have taken notice of another affidavit. Wouldn't this have put anyone on the inquiry that all is not well? That's why, in my view, it's the order of the Supreme Court. Supreme Court is the highest court of the land, but absolutely, they are not infallible. They are final because the Constitution says they are so. But it will be short-sighted arrogant for anyone to think that the Supreme Court of Nigeria is infallible. They are capable of making mistakes. And if this mistake is made in the circumstances, I think the relief granted is too wide. Then something needs to be done. Because if we don't do something and politicians get away with iniquitous conduct, displayed openly, brazenly, to the hearing and the viewing of all Nigerians, and turn around to say, no, we did not do what we said, we did not mean what we said in the other affidavits, then are we not creating room for more people to misbehave and think the court will give them judgment? So that's my worry. That's my worry.
I mean, another school of thought people are saying, I'm sure you've heard it too, you know, and I mean, everything we discuss here want to be by the law, but people are saying that the judiciary is actually too close to the politicians because I know last year, former Governor Wike commissioned some housing project, the CJ was there, and people were writing at that time that this is not the right thing to do, that the relationship between the executive are too much. Professor Adinkalo put it in his write-up that, you know, that the relationship was, you know, was scary and it will affect future judgment, and that's what has happened. But let me read this to you. He said, Supreme Court dealt with two issues when it should have addressed three. First, he affirmed the jurisdiction of the Federal High Court to hear the case. You mentioned that already. Next, on the question of whether the rump of the House of Assembly of Rivers State, loyal to the governor, could constitutionally say to pass the budget. It held that they could not, which you also said. In support of this position, the court cited precedent applicable to when the legislator sits on impeachment, a special procedure for which the constitutionally prescribed parliamentary arithmetic is different. That's because of their numbers. So the third issue, it left unattended. The court simply proceeded without deliberation or reasoning to grant all the orders asked for. Why did the Supreme Court overlook the third issue here?
I'm not a member of the Supreme Court, and I do not know why they did so. But yes, I think that there is even an earlier decision of the Supreme Court in that Pillion versus Darie or something, where my Lord Justice Onogen said that if members of the House of Assembly defected, the House of Assembly can carry on businesses, but it cannot carry on the business of impeachment. I'm not too sure whether the Supreme Court advanced its mind to that case.
Yes. I don't think so too.
The argument in this case was rooted in the question of doctrine of necessity. The doctrine of necessity. So I was not in the matter, and I do not know why because the issue here is this. And I want us to be careful not to hold some of these, not to hold this watertight arrangement that an institution like River State House of Assembly cannot carry out legislative function unless all members are present. Let me ask you a question. If peradventure half of the members of the House of Assembly were traveling and they all died, does it mean that the River State House of Assembly will not do what the Constitution says it should do until all of them resurrected or election is done? So would that grant the business of the House? I think it was in one of the cases, although not related to this, that the Supreme Court said that the Office of Attorney General is a constitutional creation and that the office can function even when there is no incumbent Attorney General in the office. So I think that under the Constitution, the vacancy in the membership of the what do you call now, membership in the vacancy in membership of the House of Assembly does not validate the sitting of the House of Assembly. So I do not know now. Section 102 of the Constitution said a House of Assembly may act notwithstanding any vacancy in its membership, and the presence or participation of any person not entitled to be present at or to participate in the proceeding of the House shall not invalidate such proceedings.
Oh, wow.
Section 102 of the 1999 Constitution. So I do not know whether this part of the Constitution was addressed at the material time that these people were moving from one end of the country to the other, flagging the flag of another political party and attending meetings that are on television and are on YouTube and everywhere. Was there prima facie evidence of vacancy for which the remaining four can act?
Let me quickly read it to you. Yeah, I know you've read it, but let me just focus, especially for our viewers. Professor Odinkalu wrote in December 2023, 27 members of the Rivers State House of Assembly loyal to Onyeson Wike, including the Speaker Martin Amawele, ostentatiously announced that they are defected to the ruling APC. In 2015, the Supreme Court of Nigeria ruled that defection is permissible only if the political party from which the legislators seek to defect to is hopelessly splintered. That is, makes it impossible or impracticable for the political party to function as such. If not, according to the court, the defectors automatically lose their seat. With the defection of Martin Awule and 26 other colleagues, the House of Assembly of Rivers State became factionalized. That's Professor Odinkalu writing. Then he said the remaining 5 members were loyal to the incumbent governor. Shortly after the defection of Amawile faction in December 2023, the premises of the Rivers State House of Assembly were demolished ostensibly on the orders of the state government. The faction loyal to the state governor relocated to the government house, where they shortly thereafter they purported to pass into law the 2024 appropriation bill for the state, which became law when the governor promptly assented to it. So the issue now is that the budget they passed last year and signed and the money they spent, you know, is there anything wrong with it, considering the judgment of today? The judgment of now, rather.
Well, from the judgment, from the judgments of the Supreme Court, everything is wrong with everything.
Oh,
and
wow.
the question is whether everything that was done with that money, including contractors that were paid, will then be ordered to refund the money. So my view is still is in Abegunde versus Ondo State House of Assembly, the Supreme Court was clear on the point. So, defection to a party other than the party that elected you, when there is no faction in that party, automatically you lose your seat. My problem with us is that the Constitution says when you defect, you lose. It's automatic. So if I were to sit as one of the panels of the Supreme Court, the question I would have asked is, was there evidence that these people say they have defected? Should we not inquire into it and solve this problem once and for all? Because I don't think it is right for judgments of court to encourage Nigerian politicians to brazenly disrespect our constitution, make statements that they are not held accountable, because in a serious, in a civilized crime, I mean a crime, your words, what you say, you are held onto it. Your words is your bond. But you can also see why in this country, people make promises and they don't fulfill that promises. And they come back for the next election. When reminded, they state another thing. Even some of these politicians that you see today had made serious indictments of the political parties that are members of today when they were on the other side. And yet today they are fraternizing and lobbying with the same political party. And they expected us to climb for them. Integrity is crucial in act of governance. And if women who are supposed to be men and women of honor and integrity decide to say one thing and be doing another thing, and those of us who have responsibility to checkmate them and hold them accountable, aided and abetted them by approving their misconduct, then democracy is in danger.
Thank you so much, sir. Before I let you go, I want us to talk about the Natasha Akpoti issue. You know, I mean, she went to court clearly, and she got some sort of relief, but the Senate, in their own wisdom, ignored that relief, and she was suspended for 6 months without pay, without all the paraphernalia of office as a senator. Is that fair? I mean, does the law allow that? I've heard some legal luminary, you know, say that that's unfair, that she's a representative of the people of Kogi State. She can't just be expunged from the house just like that, that even that there are super judgments in the past, maybe I think in the case of Undume, that said a suspension cannot even be for more than 15 days. So, I mean, you're the legal salamander here, the luminary. So what does the law say regarding suspension of a senator, representation, especially in the case of Natasha Akpoti?
Well, thank you very much, Ade. Let me be honest with you that Senator Natasha Akpoti was suspended by the Senate on the allegation that he breached the Senate rules.
Rules, okay. Clearly.
That's, for me, that's my understanding. It's not that he made false allegation, but that he breached the Senate rules, the rules and regulations of the Senate. But I ask you a question, and I've written on this extensively. The rules of Senate and the constitutional right to fair hearing, which is superior? In my humble view, Senator Natasha Akpoti made allegations against distinguished Senate President, Senator Godswill Akpabio. That allegation was reduced into writing. She laid it at the instance and permission of the President of the Senate. The Senate President presided over the proceeding in which the competence or otherwise of that petition was decided. The Senate President appointed the chairman of Ethics and Privileges Committee of the House of Assembly of the Senate of the Federal Republic of Nigeria, to which committee distinguished Senator Natasha Akpoti was referred. Distinguished Senator Natasha Akpoti approached the court fearing that her fundamental right to legislative functions is in danger of being breached or likely to be breached. He secured an order of court restraining the parliament from going on with that matter, and a day was given for them to come. That order was served on the Senate of the Federal Republic of Nigeria, the clerk of the National Assembly, and the committee. The committee fast-forwarded the date that Natasha Akpoti should appear to an earlier date other than the earlier date. The committee made a finding and submitted the report to the Senate President. The Senate President again presided over the deliberation of the report against Senator Natasha Akpoti. The Senate President of the Federal Republic of Nigeria, having presided over, hit the gravel when the two reliefs on the motion were deliberated and were to be approved. The first release was suspension for 6 months. I heard it, I had it, but the second leg of the release was a written apology, which must be done by Senator Natasha Akpoti. The nay, as I heard it, should have had it, but the Senate President hit the gavel and said I have it. I gave you all of these scenarios to show that Section 36, subsection 1 of the Nigerian Constitution is to the effect that in the determination of our civil rights and obligations, a person shall be entitled to fair hearing by a court or tribunal constituted so as to ensure its impartiality and fair hearing. Question I ask you is this. The accuser in this case is Senator Godswill Akpabio. The presiding judge in this case is Senator Godswill Akpabio. Senator Godswill Akpabio is a lawyer, and there is a principles of law of considerable activity, which is rooted in fine jurisprudence that one, nemo jude in casta sua, you can't be a judge in your own cause.
Absolutely.
Two, the doctrine rooted there is Audin Outram pattern. Here, the other side also. Now, can you, sitting where you are sitting, even not being a lawyer, think that Senator Natasha Akpoti got a fair hearing?
No,
my
she
view is no. And I would liken the situation that Senator Natasha Akpoti had found herself to a situation of the gathering of chicken and the appearance of cockroach. In the gathering of chicken, cockroach does not expect to have fair hearing. So in my view, therefore, while Senator Natasha Akpoti was being accused by the Senate of undermining the rules of the Senate of the Federal Republic of Nigeria, under the leadership of Senator Godswill Akpabio, engaged in gross constitutional insubordination when they purported to try distinguished Senator Natasha Akpoti in the manner they had done, with the Senate President as the presiding officer, the Senate President as the accuser, the Senate President through his committee as the prosecutor, all rolled in one. In a nice, normal, civilized climate, authoritarianism is not one of the attributes of democracy. Democracy does not thrive where the rule of law is ganged up. Democracy does not thrive when the rule of law is murdered on primordial partisan selfish interests. My view, therefore, without going into the merit or demerit of the allegation, which allegation in the first place has now been terminated at infancy. Nigerians have been denied of the opportunity of knowing the truth of the matter unless another way is gone through. Final point I need to let you know is that I'm the first, I think the only lawyer for so far, that have taken the question as to whether or not a member of Legislative House of Assembly can be suspended to the Supreme Court of Nigeria. And maybe because of the importance of this, I give you the name of the case so that you can go and look at it. It's the case of Honorable Friday Sani Makama versus Kogi State House of Assembly. Just a moment, let me get it out for you. It's the case of Senator Elder Dr. Friday Sani versus Kogi State House of Assembly and others. It's reported, oh, they have taken my light.
Go ahead, don't worry. I can hear you, no problem.
But you cannot see me very well again.
Yeah, but I can hear you, don't worry. It's well, that's the last question anyway, so go ahead, doesn't matter. Our viewers will understand.
So in that case, just a moment, let me get the light. Let me put maybe the reflection can make you to see me.
Yes, of your phone.
That is what we
go through. Yeah, I know. That's your last question anyway. So I mean, if you finish.
Yes. So it is the case of Elder Dr.
Friday Sani
versus Kogi State House of Assembly. Is reported in 2019 Law Pavilion Electronic Law Report, Supreme Court decision. My Lord Honorable Justice Walter Onogen delivered that judgment. The then JSC and later CJN. In that case, the question was whether there is power in any legislative houses to suspend a member from legislative duty. The Supreme Court, the trial court, my Lord Honorable Justice Josiah Majebi, J as he then was now Chief Judge of Kogi State now, agreed with me that no legislative power house has the power to suspend any member of parliament. Kogi State House of Assembly went on appeal to the Court of Appeal. The Court of Appeal set aside the judgment of the Kogi State High Court on the ground that the procedure that I used, which was originating summon, was wrong, and that we should go back for retrial using what we call the writ of summon. Highly dissatisfied, I went on appeal on behalf of the appellant to the Supreme Court. The Supreme Court heard the appeal, and at the conclusion, this is what my Lord Honorable Justice Walter Onoge said, quote, I am of the view that this appeal succeeds in part and order as follows, that the judgment of the court below be and is hereby set aside, that the judgment of the trial court be and is hereby restored and affirmed, that the respondent be and are hereby ordered to pay the appellant all his pending salaries, allowances, emoluments, and money due to him to resume his legislative duties forthwith. The cost of this appeal is fixed at 1 million naira against each set of the respondent and in favor of appellant, unquote. In other words, my Lord Justice Majebi held that no members of the House of Assembly or Parliament can be suspended by that House. The Supreme Court restored that judgment. In other words, by the extant decisions of the Supreme Court and the Court of Appeal in Ndume, in Dino Melaye, in Omo Agege, and all other one by the Supreme Court, and the one that even my brother, Femi Falana, SAN, did in Bao City, Rifikatu case also, there is no power in the National Assembly to suspend one of their own, because doing so is a gross violation of the Constitution that says that you must sit for a certain minimum number of days in a year. So, and to compound the matter, in this one, they went further to even say he will not receive his salaries and allowances, and all our security aids are withdrawn. In other words, my submission in conclusion is that the National Assembly or state houses of assembly are not employers of any members of the House. The employers of the senators, House of Representatives, and houses of assembly of each of the states of the Federation are the people who voted them and sent them to Parliament. Only the people and only the people can discipline their employee, which are the senators and House of Representatives. In other words, therefore, my humble view is that the decision taken is just for a temporary amusement of those who want to be amused. You will, in not too long, a court of law bound by authoritative judicial precedents will set that decision aside. And that is why I agree with Natasha that this injustice will not last long.
Thank you very much, sir. Jibrin Samuel Okutepa, the legal salamander. Thank you for your time. Thank you for always heeding our call. We respect what you do. Here is no holds barred, and you said it the way it is. You refer to the Constitution, you quoted past judgment, and you highly revered. I want to use this opportunity to call on Twitter. I was checking your account. I see they've suspended it, and please, Twitter, restore Mr. Okutepa's account. I know some of your people.
I don't know why Twitter had done so, because at least if anybody had written any, I have not written anything.
I know, we all follow you. So you should have a right to defend yourself if there's anything.
If there is anything, I think if an international organization like that can also engage in this kind of draconian denial of right to fair hearing, then people should begin to insist that they should get out of it, because if people are not on Twitter, Twitter will not make money.
Absolutely. Unfortunately, the options are not, they don't carry as much weight as Twitter. I know more than half of the people there may not like what's happening, but they are still there. So like you said, if people are still there, then they'll still make money. But no problem. We'll do what we can do for you. You're a voice of the people, so we respect what you do. Thank you very much, sir. To our viewers, you've heard it from the man himself, what the law says. The Supreme Court is not infallible. That's a major summary. They are human beings. They can make mistakes. And the legislators are like Senator Apoti. They were employed by the people because they were elected, So the law is clear, like Ndume, Okurumu, and past senators that were suspended. It is wrong before the law. So like Apoti herself said, it will not stand the test of time. So SAN Okutepa, thank you very much. Thank you so much. And to our viewers all over the world, thank you one more time. See you next week, Friday, for Atlanta Discuss. Thank you. Bye.
Thank you very much. I hope one of these days I will come to your studio in Atlanta.
We can't wait to see you. We can't wait to see you.
Thank you.